we now come to the next segment, which is chapter 6 of part 3, which is the process for individuals and partnership firms. So now what we are getting into is who are the adjudicating authorities. So you just have to remember the following points. 179 says the adjudicating authority shall be the DRT for matters relating to insolvency of individuals and partnership firms. But surprisingly, it uses the term subject to the provisions of section 60, which is nothing but the adjudicating authority for corporate persons. Now, the exception that's provided is when there is a guarantor who's a person for a corporate, then that gets attached to NCLT and not to DRT. That is why you have subject to the provisions of section 60, because section 60 makes a specific reference in subsection 3 where they say an insolvency resolution process or bankruptcy proceeding of a personal guarantor of the corporate debtor pending in any court or tribunal shall stand transferred to the adjudicating authority here, which is the NCLT dealing with the IRP. So subject to that provision of NCLT, the DRT shall be the adjudicating authority for individuals and partnership firms. Now the second logical question is, which DRT should I go to? It's the debtor, it's the DRT in the jurisdiction where the debtor actually and voluntarily resides or carries on business or personally works for gain. Then the section also speaks about what the DRT's powers are. They have jurisdiction to entertain and dispose of suit or proceeding made against an individual debtor, claim made by or against an individual debtor, question of priorities, question of law, question of facts arising out of the process. This also speaks about limitation, saying that the period of moratorium shall not be included for the purpose of computation of the limitation period. This part also says a civil court shall not have any jurisdiction and on a matter which has been referred on which the DRT or DRAT has jurisdiction under the code. It also says no injunction shall be granted by any court, tribunal or authority in respect of any action taken or to be taken in pursuance of a power conferred by the DRT or the DRAT. Now, if you are aggrieved by the decision of a DRT, where do you go? You go to DRAT. Within how many days must you go to the DRAT? Within 30 days of the order. Is there a condonation and an extension? Yes, it's 15 days that can be given by the DRAT. What is the next level of appeal after DRAT? It's the Supreme Court. So how soon must you apply to the Supreme Court? Within 45 days of the order. Is there an extension here? Yes, it is available. It is for another 15 days. So it's 30, 15 and 45, 15. Then we come to expeditious disposal of applications. This is provided for. If you notice in several places in the Act, the adjudicating authority and the DRT in this case is required to either dispose an application or pass an order. Right? So when an application is not disposed or an order is not passed within the period specified in the code, the DRT or the DRAT shall record the reasons for not doing so. That's the number one. And the chairperson of the DRAT, only him, after taking into account the reasons so recorded, shall permit the period to be extended by not exceeding 10 days. So there are three conditions here. Extension is possible. Reasons recorded in writing, after taking into account the chairman DRAT for a period of 10 days. With this we conclude chapter 6 of the code, which basically deals with adjudicating authorities under the code.